Good afternoon, everyone. France Hong, as I mentioned, one of the firm's partners. Delighted today to continue our webinar series on the intersection of GovCon, the law, and generative AI. Today, we're going to go global. We're going to talk about the intersection with international trade regulations. And I'm really pleased to have me joined today by Katie Cusack and Adam Munitz, two of the firm's experts in our international trade and transactions group. Generative AI and international trade. There's not an obvious connection. So before we jump into what is that connection, I'd love for Adam and Katie to introduce themselves. So Adam, why don't you start?
Thanks, France. Well, great to be on. And thank you in advance to Katie for all the work she did in this presentation. We're really looking forward to the discussion. Again, my name is Adam Munitz. I co-chair the International Trade and Transactions practice at Fluet. My focus is on trade compliance, regulatory compliance. So I focus on export controls, sanctions compliance, CFIUS, that is the regulation of foreign investment, and a variety of other regulations that touch on international trade and global commerce. Katie?
Yeah, so my name is Katie Cusack, and I'm an associate in the international trade practice here at Fluet. And I work with Adam and work in sanctions and in CFIUS and export control when it makes sense. And I'm very happy to be here, very excited.
Great. So Adam and Katie, before we jump into the really meaty part of the webinar, would love to have you two describe what's the most interesting or unusual thing you've used GenAI for to date?
I'll start, France. I mean, I am absolutely an admitted novice on GenAI. I think you and I have talked about this before, but I think I represent that large category of individuals that have, listened to a lot of podcasts about AI and about the risks and about the implications and the benefits, but haven't used it extensively. But I think that Katie has some illustrative experience, maybe that she, in her personal life, that she could share that's more interesting than my experience.
Well, unfortunately, Adam, I'm very much in the same boat as you, but my limited experience with AI has really nothing to do with international trade law. It's looking at, putting prompts into AI systems and, seeing, generated like interior design spaces or things like that come out of it. So really not on topic for here, but that's kind of what my AI use background looks like.
So thoroughly disappointing across the board, friends.
Well, this actually feeds into something we were just talking about before we started the webinar, which is if you read social media, if you read the blogs, you listen to the news, it would seem that everybody's using GenAI. Most of us have missed the train. Organizations have to play massive catch up. I actually disagree with that. I think we're still very much in the early adopter, early stages. There is still plenty of time to catch this train. The train, while it's pulled away from the station, has not, is pulling away from the station, has certainly not left the station. And there's still a lot of open questions, as Adam and Katie, you're gonna dive to in a second, regarding the use of GenAI. Everything from the nuts and bolts of like, what are the right use cases for an organization and individual, to all these legal permutations that affect the use of generative AI by businesses. So speaking of that, so Adam, let's keep this simple to start. I'm a company here in the DC area. I'm either interested in doing work internationally, or I do work internationally, or I'm thinking about doing something involving a foreign entity, maybe an investment, maybe making an investment or getting an investor. Why should I care about international trade regulations and AI? Those things seem worlds apart to me. What's the simple answer?
Yeah, great question. The simple answer is that the regulatory landscape is anything but simple, and it's still very much evolving. It's very much ambiguous, which is scary to first-time exporters or those that are doing business internationally with AI for the first time. We work a lot with defense contractors that are exporting lethal munitions and other hardware, sensitive hardware overseas. And while the lethality of those programs is inherently risky, at least the regulations surrounding their export is clear, right? If you're exporting a tank overseas, it's very clear how that tank is regulated. As we'll discuss with AI, it's ambiguous, and that puts a lot of risk on on companies and those that are trying to, in particular, figure it out themselves. So it's fraught with risk right now, particularly because the regulations are, as I said, ambiguous and evolving.
Okay. So, Katie, this is not meant to be a law school exam question. So, but putting aside all the intricate regulations, devil's in the details when it comes to export compliance, why do we have an export compliance regime? What's the big picture? What's the policy reason behind it? Because that will help kind of inform our discussion.
Sure. So I think, sorry, excuse me, a big piece of it is going to be national security, right? So we're going to be trying to make sure we, sorry, we as a country are going to be trying to make sure that we're not sending, information, technology, products overseas that then leave us open from a national security standpoint. So that's where a lot of these export control regulations that Adam is going to speak to in a couple of minutes are going to be coming from. And I think to go back to kind of your opening question with us, I think it is, AI is just like any other product where you don't necessarily have to, use it extensively to try to figure out how it works and then how that works from a regulatory standpoint. So I think, the use piece of it and understanding how, at least in broad strokes, AI might look and how it might look to the government, those might be two different questions. So I'm excited to get into this topic, but I hope that answers your question.
Yeah, but Adam, I'm a little confused. Like a tank is designed to shoot and blow up things. I've shot a tank. Like AI is designed to help you. I don't understand the connect. Those things seem worlds apart to me.
Sure. So from an export control standpoint, for those that are not familiar with the alphabet soup of export controls, let me give a very high level overview of the two regulatory regimes. I think that'll help frame the discussion.
Great, Adam.
First, there's the international traffic in arms regulations overseen by State Department, which regulates the export of what we call defense articles, right? Really, so military hardware and associated software, services, and information. That's the most restrictive of the regulations. Beneath that are the export administration regulations overseen by Commerce, which regulate everything else, which can broadly be considered dual use items, right? Items that have both a military and a commercial application, but really anything other than what's controlled under the ITAR. So there tends to be this misconception in industry that something can be controlled by a regulation other than the ITAR or the EAR. It's one or the other. It's mutually exclusive. So when we look at AI and we try to plug it into that framework, that's where I think some of this confusion emerges, right? How is it controlled under the ITAR and the Export Administration Regulations, the EAR? How has it been controlled to date? And bottom line, as I said before, it's evolving. It's still very much unsettled. If you look at the ITAR, the International Traffic and Arms Regulations, and you look at the list of items that are affirmatively controlled under the ITAR, which is called the United States Munitions List, there's zero reference to AI in there. None. I mean, you can do a Control-F search. There's no reference to AI. So if you pivot to the Export Administration Regulations instead, and see how AI is regulated there and where it's referenced under the regs, it's referenced once, right? There's only one affirmative reference to AI, to our knowledge, in the whole of the Export Administration Regulations, which is kind of shocking, right? Because we hear a lot about hearings on Capitol Hill about the dangers of AI. I mean, you'd think that Skynet's about to kick off and that Robert Patrick's going to come running to my office, T1000 in a minute now. Yet, nonetheless, it's nowhere to be seen in the ITAR, and it's only referenced once in the EAR. And that reference is to neural networks, which I don't pretend to understand, but neural networks are essentially, it's deep learning, right? So it's a type of machine learning process that uses interconnected nodes or neurons in a layered structure that resembles the human brain. And the area in which it's referenced is under a particular category of the EAR, which refers to neural computers. And I think it's worthwhile just to read how those are described. Neural computers are computational devices designed or modified to mimic the behavior of a neuron or collection of neurons. So computational devices which are distinguished by their hardware capability to modulate the weights and numbers of the interconnections of a multiplicity of computational components based on previous data. it's a lot of words. It's a lot of big words. But bottom line, that is highly evolved artificial intelligence, and the software that it controls is highly evolved. So one would think that the export limitations on neural computers are relatively strict, particularly because of the hearings that have occurred and the abundance of public policy writing that's out there. But when we look at how these neural computers are actually controlled under the export administration regulations, it turns out, because as a footnote, under the export administration regulations, it depends on where one is exporting their good or service. It turns out that for the export of neural computers, no license is required for a handful of countries. And I'm going to read them just because I think it's fascinating to look at how many countries and which countries one could export in general, with some caveats, these neural computers without getting any sort of license, any sort of prior approval from the Department of Commerce. Argentina, Australia, Austria, Belgium, Bulgaria, Canada, Croatia, Czech Republic, France, Germany, Hungary, Iceland, Mexico, the Netherlands, Spain, Sweden, South Africa, Turkey, and the United Kingdom, and elsewhere. So that's kind of shocking, right? That despite how sophisticated neural computers are, one could, again, with some caveats, export to any of those countries without any sort of prior approval from the Department of Commerce. Now, it's particularly remarkable when you look at how some other items of hardware are controlled under the EAR. For example, certain firearms, non-automatic and semi-automatic firearms controlled under the EAR, can only be exported without a license to Canada. So anywhere else that you would want to export some sort of firearm in the world would require a license. And the same goes for certain kinds of body armor, gas turbine engines, and non-military UAVs. So there's an obvious disconnect there, which I find really interesting, that the controls on those pieces of hardware, which are not particularly sophisticated relative to this AI boogeyman that we've heard so much about over the past few years, those pieces of hardware are highly controlled, and neural computers, that sophisticated AI capability, is controlled at a significantly lower level.
Yeah. So Adam, what's an export in this circumstance? Is it mere usage, right? If I create a model and I let somebody from one of the countries not on your list use it, is that an export under this regime?
Most likely, yes. So we tend to think of exports as physical shipments, right? Because that's how we've been trained. But an export is really the sharing of anything that's controlled with a foreign person, whether it's software, whether you are giving them the ability to access it online and utilize it, or if it's data, if they have access or exposure to that data, which is particularly problematic, as you can imagine, if you have foreign employees that are working with AI-related data. The fact that a foreign person has access to data is an indication that an export has occurred. So it's much broader than one would think.
Got it. How about this issue of end use and user limitations? How does that apply to AI technology?
Yeah, so I think that when you look at the end use limitations, are something of a floor, something as a catch-all to prevent the rapid proliferation of AI to all corners of the earth. The US government is trying to plug these holes. It's trying really quickly to plug these holes. And we see that in its regulation of geospatial imagery software, for example, which from about 2020 until January of 2023 was tightly regulated by Department of Commerce. Essentially, that geospatial imagery software could only be exported to, again, Canada without an export license. But those regulations, those restrictions sunsetted earlier in the year. So at this point, geospatial imagery software, which has a significant AI component to it, is regulated at the lowest possible level. It is regulated, to our knowledge, the same way as your couch cushions, stapler, and sneakers, right? Which is shocking, right? And hopefully there are going to be some additional precautions in the near term to again plug those holes. But in the meantime, we're relying on two backup measures, so to speak, to prevent the proliferation. One is the one that you mentioned, which is an end use limitation. And what the government's done over decades is require that for all goods, services, information, software, regardless of how it's controlled, If it's going to particular individuals that have been restricted by State Department, Treasury, Commerce Department, or others, or if it's being exported for a prohibited end use, such as the development of missile technology or CBRN capabilities, then a license, a prior approval would be required, even if it's a low-level, widget like a stapler, right? So that's one precautionary measure. The other is that to the extent that software, such as AI software, for example, is specially designed for a particular piece of hardware, then generally that software is controlled the same way as hardware. So what do I mean by that, right? If while, as we've discussed, AI software may not be affirmatively regulated across the board, to the extent that I specially design AI software to work with some sort of missile technology or tank or submersible, then the license would be required, because now it's associated with that hardware. So that's another fallback option under both the EAR and the ITAR.
Great, Adam. So EAR, ITAR, that controls the export, the potential export of AI technology, as well as a bunch of other technology, obviously. But there's another regulatory regime. So I'm a company, I develop AI-related technology. I'm interested in getting investment. Obviously, this is a very hot investment field. I get a term sheet, and it's from a foreign country. So, Katie, what's my considerations there?
Sure. So your first consideration is going to be involved in the world of what's called CFIUS. So CFIUS is the Committee on Foreign Investment in the United States. It's an interagency committee, and what it does is it reviews foreign investment in or acquisitions of U.S. companies or property. And what it does is it really looks for considerations of national security. So there are a couple of different pieces of this that might come up, and I'll talk about those in a second. But what's really important to know about CFIUS is that when they're looking at this question of national security, they have a somewhat broad definition of what that is. And I think it's almost like the term export, where it's probably broader than people would necessarily think right off the bat. And then the committee also has a somewhat broad authority to take action depending on what national security concerns come up during the course of their review of that particular transaction. So CFIUS is going to, look at information that they either acquire, that's public, or maybe sometimes, confidential or classified information. But they're also going to be relying on companies to essentially submit information to the committee itself. So there are a couple of requirements for when these transactions are being proposed or going through, where you would be required to submit information to CFIUS. So the first situation is going to be if the foreign person that is looking to acquire a piece of your company, France, is looking to acquire a substantial interest in the company. It also requires that your company is involved in some kind of critical technology, and that's defined under the regulations. And under this situation, a foreign government would have to have a substantial interest also in the foreign entity. So there are a couple of things going on there, but all of those boxes would need to be ticked for that to become a mandatory filing situation. The other situation.
So, sorry, Kate, just to jump in and kind of highlight that for people, because I think that can be a little squishy, right? There are really two buckets that Katie mentioned when it comes to mandatory notification to CFIUS. One is where there is substantial government ownership, and the other is where there's critical technology that I'm sure Katie will talk more about that the company has. So, I mean, those are, broadly speaking, the two buckets where a mandatory filing could be required. So, Katie, please continue.
Right.
Well, yeah, let me follow up on that, Katie. So, it's an either situation, not an and. It's an or, but not an and. Correct?
Correct. But that was just the first situation. So the first situation is dependent on kind of those factors. The second situation is going to be, looking at this from more of almost an export control framework, where if the US company was going to be, exporting their good over to this proposed foreign investor, would they need an export license to do that? And that also has that critical technology, component to it. So those are the two kind of situations where a filing would be mandatory. And there are going to be different definitions that come up within each of these categories that, are defined in the regulations and have different pieces of it. But those are kind of the two buckets. I think it's also important to note that even if you determine that a filing is not mandatory under the regulations, you still have the opportunity to submit a voluntary filing to the committee. And that might be really prudent, particularly with the last couple of years, the government really indicating that AI is of national security concern. So there's going to be certain strategic plays in that too, even if you go through those analyses and determine that maybe a declaration is not, strictly speaking, mandatory under the regulations.
Is there a floor of the level of investment? I mean, if somebody puts $10 as a private investor, or is it any investment by a foreign entity where the government is involved, or where it's a critical technology, or there's an export concern, would trigger potential CFIUS concerns?
Sure. So in the first situation, it's based on what's called a substantial interest. So that would probably be more than about $10, but unless the company is really quite small. But the second situation doesn't really get into a dollar amount. It's more focused on kind of the export control piece of it. So it's a little bit of a different question. And both of those situations you would have to take a look at. I think it's important to, when companies are trying to decide whether a filing is required, that they take a look at all those different factors, right? Who are the people who are looking to acquire the company? Is there any sort of connection to a foreign government? What is that amount of investment that they're looking at? What products does the US company produce, and how are those controlled under the US regulatory scheme? So there's going to be a lot of different things that come up that are important to really think through when you're thinking about the viability of this potential investment opportunity.
Yeah, and I think, France, just to follow up on that, CFIUS is very much focused on control, right? So it's not so much the amount of the investment, it's the extent to which, bless you, the foreign acquirer or foreign investor can control that company. And in fact, in recent years, with the passage of legislation that's tried to enhance CFIUS's authority, CFIUS has been focusing on non-controlling investments, right? So-called past investments where there's still, board representations or board representation or authority to that effect, where there's some level of control, even though it's not majority ownership. So again, the takeaway there is it's control. It's the extent to which the foreign investor acquirer can manipulate the company rather than how much it's putting in.
Got it. So you, as a company, you shouldn't just simply say, well, they're not taking a majority stake, I don't have to worry about CFIUS. It's much more nuanced than that, because the concern is that even, say, a single board member potentially could have access to information that there would be a United States interest in determining whether that should or should not occur.
Correct.
So that was actually, yeah, go ahead, Adam.
Yeah, in part because CFIUS's authority to unwind block transactions is so extreme. Even if it's a de minimis investment by a foreign national, the question is, who is that foreign national, right? Are they from a country such as China that's receiving particular scrutiny? So it's a kind of a multi-layered totality of the circumstances type test.
Okay, so this sounds very complicated. I'm a lawyer. I've actually done a CFIUS transaction with regards to an investment in one of my companies. It still feels complicated. So I'm a business owner. What's the trigger for me to find a lawyer who knows about CFIUS?
Yeah, well, I think if you have any of those kind of early signs, right? It's a foreign investor that's coming to you. They're looking to invest and get some piece of control out of it, right? Like there are going to be different pieces of it that should kind of put that light bulb on where you think, okay, I might need to talk to somebody who works in CFIUS, who is an international trade attorney. Those would probably be the kind of the early touch points. And I think the earlier that that you can kind of wrap your head around it, the earlier you can figure out whether, that proposed transaction might require something or maybe not.
Okay, so let me ask a double-sided question here, double-edged question. What if I choose to ignore this? What's the worst that can happen, right? And then how can a lawyer help?
Sure. Please don't ignore it. So essentially, I mentioned before, CFIUS has fairly broad authority to deal with national security concerns that come up. One of those pieces of authority that it has, it can essentially undo your transaction. So if you decide to ignore CFIUS filing requirements, there's a national security concern kind of embedded in your transaction, and CFIUS finds out about it, they can force you to undo it. And that's not something that I think a lot of companies would be terribly thrilled about, right? If all of a sudden now their transaction is mooted. So it's best to at least know what it is that you're looking at and what requirements might be in place.
Yeah, and I think it's ultimately a judgment call in instances in which a declaration or a notification, whatever it may be, is non-mandatory, France, because there are, as you can imagine, many transactions every day that fall beneath the CFIUS thresholds. In that case, why do it, right? Why invite the government into your affairs? And there are a variety of circumstances in which one would still want some degree of CFIUS approval, even if it's what we call the informal CFIUS shrug, right? One instance that we've seen before is where the U.S. company is a government contractor. Even if CFIUS approval is not required, that government contractor, of course, has government customers. And as you probably know, in government, the left hand does not necessarily talk to the right. And your average contracting officer knows nothing about CFIUS, knows nothing about this approval process. And when they receive notification pursuant to the contract that there's going to be some sort of foreign ownership or foreign investment, whatever it may be, they want assurances that that risk has been mitigated. And in that instance, it's awfully useful to be able to say to the contracting officer, well, we have CFIUS approval, right? That's seen by them as kind of the gold standard. It's a nice safety blanket. So that's where it gets tricky. It's ultimately just a judgment call based on all the different factors.
So two questions. What does a lawyer do, right? So I'm thinking about a transaction. I contact Katie, you or you, Adam. What do you actually do to help, right? And second, is this going to slow down my deal? Like, I'm trying to get funding in. Is this like, do investors hate this? Is this going to like delay me getting money 6 months, a year, tank the deal? These would be my concerns if I was taking money from, say, let's say SoftBank from Japan, right? And had to get CFIUS approval. So how does a lawyer help? And is this going to hurt my deal?
Sure. So I'll start with the first question. So a lawyer can help walk you through what might be required in terms of, is there actually a filing requirement for what we're looking at? If there is, and you don't want to go through that, how do you restructure that proposal to not have that be the case? Or, maybe it's the case that it's not required, but it makes sense to do a voluntary filing anyway. But they kind of help walk you through those options and really do the analysis of what are we looking at here. I think the question of will it hurt your investment? So I think, like Adam was mentioning, there can be a lot of good that comes through a CFIUS approval, or at least a CFIUS shrug, where you then have that bit of assurance with this investment piece, where if you didn't go through the CFIUS process, you might be wondering, or other investors might be wondering, well, was that really permitted? And you don't particularly want that. That's a little bit more risky. I think in terms of the timing, a mandatory declaration or a declaration, I should back up. There are two types of ways that you can submit information to CFIUS. One of them is the declaration that we talked about earlier. And that is going to be a shorter form than where a lot of the voluntary pieces of information come in, which is through what's called a notice. And there's a little bit of, back and forth there too with which one is which, but they're going to have a little bit of a different timeline associated with them for the review. But I'm not sure that I maybe I can let Adam speak to whether.
Sure. No, I thought that was great, Katie. I mean, but in answer to your second question, Franz, yeah, investors, acquirers, they don't like this process, right? No one really likes this process because it can add months. I mean, at a minimum, with a short form declaration to CFIUS, you're looking at a 30-day review period. Now, that 30-day review period is assuming that CFIUS doesn't come back and say, that's great, thank you for the declaration, now we want a full notice, and now you're subject to a much longer timeline. So, I mean, at a minimum, it can be months. We've been a part of complex CFIUS transactions, though, where CFIUS has restarted the clock 3 times. And so it's taken up, up to about 7-8 months before approval was required. In one instance, after all that, approval was not required because the riders attached to it were just too severe. So it does add time, but of course there are benefits to the regime in that there's some certainty, right? It's nice to know that when your transaction closes and funds are wired, ownership changes, that out of nowhere the government's not just going to pop up and say, yeah, we're not so comfortable with this, we're going to unwind. So pros and cons, but yes, it can add a significant amount of time to closing.
Yeah. So I'll just add, having been part of an investment involving a CFIUS process, so Fluet has an M&A practice alongside the practice group that Katie and Adam work in for international trade and transactions. They work together on these types of issues. If the M&A practice group works with the international trade practice groups, I will say having the legal teams married up so that your deal team is talking to a team that has knowledge of CFIUS can avoid some of these pitfalls, can actually speed up the process in the sense of these things don't get better over time. And there may be options in terms of structuring the deal differently that will turn something that would have been a mandatory declaration to a voluntary one with a quicker review, a deal team that has a good relationship with a team like Adam and Katie that has strong relationships at CFIUS can get some, I wouldn't want to say informal acknowledgements, but there are ways to get an understanding of what might be required and to build that into the deal timeline. So these are all great points. Adam, let's back up to ITAR because I didn't ask the set of questions of you that I asked of Katie, which is, I'm a company, what's the trigger for me to think about ITAR, EAR, and the AI product that I'm selling where I should consult with an international trade attorney?
Sure. No, I'm glad you backed up to that, Franz. That's important. I mean, anytime there is either a foreign buyer, a foreign customer, or a foreign person really anywhere in the chain, right? So as I mentioned before, if a company that works in this space or in many spaces that works with sensitive technology or hardware has foreign employees, then that's a trigger too. So anytime you have a foreign person anywhere in the mix, whether it's a reseller, customer, investors we discussed, employee, that's the trigger, which point companies should reach out to Trade Compliance Council and understand what the left and right lanes are and whether there are any sort of approval requirements in place.
How about simply just putting a product out on the internet that anybody can buy? Does that trigger ITAR? I mean, there's hundreds of products being released that anybody can sign up for with an account.
It can. And, software companies, internet companies have spent a lot of money trying to mitigate that risk. And in some cases, it's impossible to mitigate that risk. But certainly, yes. I mean, there are just the act of providing a solution to a foreign person, even though there's no charge, could in and of itself constitute an export. And so that's an instance in which Trade Compliance Council is very much necessary. And it's also, important from a sanctions compliance standpoint too.
Got it. Okay. Thank you, Adam. So let's move to sanctions, which you just mentioned. What are sanctions? That sounds like a bad word.
Sure, it's a bad word. It's not a word most companies want to hear. Yeah. So big picture, stepping back, broadening the aperture. The U.S. sanctions regime, managed primarily through Department of Treasury, specifically Office of Foreign Assets Controls, has implemented a variety of restrictions on trade with particular countries and particular individuals and entities that limit the ability of U.S. businesses and individuals to transact with those countries, individuals, and entities. But also, to a certain extent, it limits the ability of foreign persons to transact with those individuals, entities, and countries as well. There are comprehensive sanctions. We're talking big picture here, right? Comprehensive sanctions which apply to countries as a whole and all nationals of those countries, such as Iran, North Korea, Syria. And then there are more non-comprehensive targeted sanctions that have been imposed on, as I said before, particular individual or entities. One common misconception amongst the US business community is that this only restricts transactions. It only restricts the flow of funds. But a particular note to AI companies and internet companies, it's really anything of value that can be restricted. I'm happy to elaborate on that.
Yeah. So what does that mean? Anything that of value, right? Like, so do I have to make sure that North Koreans aren't using my AI product at an individual level? Do I need to check every person against a sanction list? Do I need to block every North Korean account? What does that mean?
Yeah. So I think there are a variety of scenarios in which this can play out. And the first is one in which it's for a fee, right? Where the access or software is being provided in exchange for some sort of monetary remuneration. And in that instance, yes, it's important to ensure that the individual or the entity that's paying that fee has not been sanctioned or is not a national of a country that is subject to comprehensive sanctions. What I think is more interesting is where, and this is, I think, alludes to one of your earlier questions, it plays out in a much more interesting way where the product is not being provided, the software is not being provided in exchange for any sort of compensation. We worked with a company years ago that had a data platform. And like many companies, in order to increase their sales, they have a free taste, right? They have a free trial program, a trial period in which any user can access their capability for free to a certain extent for a certain amount of time. And they actually inadvertently provided access to this data platform to persons that came from sanctioned countries, and they actually had to do a disclosure to Department of Treasury, and it all worked out just fine. But even in that instance, where they were not, directly benefiting overall, they were still subject to an investigation by OFAC. So there are a variety of measures that can be put in place to mitigate these very murky, ambiguous risks. I think the chief one is a compliance program, right? Is being deliberate. So much of trade compliance comes down to just being deliberate and thoughtful. A compliance program forces a company to think very deliberately and methodically about the risks that exist with respect to its particular offerings and how they're going to address those risks in their particular situation, in their particular circumstances. Out of that compliance program should come some sort of a screening process, right? Some sort of due diligence process, whether the software or service is being offered for free or whether it's being offered in exchange for some sort of compensation. But some program should be put in place, if possible, in order to check the identity of individuals that are either paying for and or accessing the system. There are a couple different ways to do that. One way is to require the creation of a user profile, right? Even if the access is free, a user profile can give the U.S. company the information it needs to conduct some sort of screening and due diligence. The other is to put in place an IP address blocking protocol in which certain domains, certain address, IP addresses are blocked due to their ties to sanctioned countries or sanctioned individuals or entities. And then, of course, to the extent there is some sort of remuneration from a monetary standpoint, if there's credit card information being exchanged, that's an easier way to obtain the information necessary to screen out restricted actors or nationals of restricted countries.
Adam, what's the standard here, right? Is it I have to make reasonable efforts, and if somebody gets through, I'm okay? Is it any breach I'm responsible for despite my best efforts? Like, what's the standard here I need to meet as a company? That's a really
great question, and it's complicated. All this is, but in general, it comes down to knowledge, right? Which is generally a defined term. But is the company taking every measure it can, going to whatever lengths it can so as to inform itself of the risk? Now, in general, sanctions are tied to a strict liability regime, right? If you violate sanctions, then you are, of course, liable. You violated the laws. But from an enforcement standpoint, OFAC and other agencies will really look at the extent of knowledge and perhaps intentional blindness.
Okay. And if I run afoul of sanctions, what happens?
Sure. So there are various penalties, civil penalties, criminal penalties, administrative penalties. Generally, companies are looking at a severe financial penalty, whether it's criminal or civil in nature. Individuals that are part of a scheme or conspiracy to violate sanctions could face imprisonment. And then, of course, there are administrative consequences such as potentially debarment, or in certain circumstances, we could have a whole nother webinar on this, maybe we will. Under certain circumstances, foreign individuals themselves that run afoul of these sanctions could also be added to lists of restricted parties and thus lose the ability to transact with U.S. persons and, most importantly, U.S. financial institutions.
Yeah. This sounds very similar to export compliance. So where's the overlap, or where's do I need to, like, if I take care of the sanctions portions, does that take care of export compliance as well?
I'd say that both come down to situational awareness, right? Okay. Mitigating both of these risks comes down to understanding the transaction. Sometimes U.S. companies are so excited with foreign transactions, in part because it takes so much of an investment to get a foreign sale, that they blow straight past the due diligence stage. But it's really that due diligence stage that will highlight these risks. Is there a foreign person involved? Is there a sanctioned person involved? Having that situational awareness, having a full understanding of the kind of the informational landscape is what allows U.S. companies, U.S. persons to navigate successfully both export controls and sanctions, and also CFIUS.
Okay. I mean, has the United States taken any action for an AI company, like putting up a website and then somebody from a from a sanctioned company, a country that a neural net should not be exported? Have they taken any action like that to date? That seems...
I'm not aware of it. I wouldn't be surprised if it has. Most of these, as I'm sure you know better than a lot of us, most of these investigations and the consequences are private and aren't even vulnerable to FOIA disclosures. But if it hasn't happened yet, I'm sure it will soon, although I hope not.
Okay, great. Well, let's back up and talk big picture again. Just about the practice of international trade law, right? And compliance individuals. There may be some of those as well, our fellow export compliance, ITAR, EAR, CFIUS, sanctions bar members here. Katie, how do you think this is going to affect the practice of international trade law?
Yeah, so I think that there are probably two big ways that AI is going to really impact trade and compliance professionals in their jobs. So one is that, AI really helps you sift through a lot of information really quickly, right? Like that's its big selling point. So it'll really help with, kind of the primary drafting of things like maybe license applications, or running through information maybe from like a sanction standpoint to kind of red flag certain transactions. The flip side to that is that it's not just going to help businesses, on the private side. It'll also help the government to red flag certain transactions and to go through a lot of information really quickly as well. So I think it's important to kind of keep in mind that, like, it can be a really, really helpful tool, but it also might mean that there are maybe more enforcement actions that come up in the future as the government is able to more quickly sift through a lot of this information on some of these different types of international trade practice areas that we've been discussing today.
Got it. So trade lawyers may be using AI to complete some of their work, and the government may be using AI to help review some of their work. So it's going to be AI versus AI, perhaps. So Adam, your thoughts?
Yeah, I think, Katie put it well. I think that the stakes will very much increase, right? I think the government will be able to adopt a much more robust enforcement posture because it will have access to more information, and it will presumably be able to sift through that information much faster. So companies that may have previously flown under the radar from an export licensing standpoint, from a sanctions standpoint, I think in particular, will have much more to fight against in the future from a government enforcement standpoint. And I think that the role of lawyers, as with everything AI related, the role of lawyers is going to fundamentally change, right? I mean, companies are no longer going to be asking lawyers at $1,200 an hour to draft their export licenses for them, right? They can probably use some sort of GenAI capability to mostly do so themselves. Where the role of lawyers will still be critical is in advocacy, right? Will be in voluntary disclosures, right? Will be in coming up with mitigation strategies. And then I think there will still be some nuanced requests for approvals, whether it be a sanctions license, whether it be an export license, whether it be a CFIUS approval, where some degree of human involvement will be required. But it's going to be, again, as with every industry, it's just going to be a different kind of value-added role.
Yeah, I also think it's probably important to note that while there is already a lot of regulation out there that's not specific to AI, we're going to probably see more regulation come up around this space. And we're starting to see pieces of that in terms of, let's say, from the investment standpoint of US companies investing in foreign AI. So there are going to be more rules and regulations. We saw a notice come out somewhat recently saying that certain of those US investments in foreign AI companies, particularly Chinese and companies in Macau, would be banned, and some of them will have a notification requirement attached to them. So I think that it's also important to know what your other requirements are from a business standpoint as more of these regulations are put in place.
Yeah, I think to follow up on that, the U.S. government is still so shell-shocked and appalled by the role of various U.S. companies in China's extensive surveillance framework that it's really trying to cut that off in the front end this time with respect to AI. So as Katie mentioned, there have been robust regulations floated that focus on outbound investment so as to kind of help ensure that the U.S. industry does not inadvertently power the development of advanced AI capabilities in China and elsewhere.
Great. Erica, if we have any questions, we'd love to highlight those. Oh, you just sent a note. Yes, we're open to questions from the audience. I just want to touch on something that you both mentioned about the use of AI. I've said this a lot. I think I even said in one of our previous seminars, there's this concern that AI is going to replace all of us, right? And I tell people time and time again, for those of you who've used the technology, it's amazing, but it also becomes very apparent that in many cases it's inadequate, right? In the sense of, if you can't get 100% solution without AI, you're not going to get it with AI. It will provide you great answers, and I call it a 70 to 85% solution. But in order to get 100% solution, you need to know what 100% solution looks like, right? And that's the human component of this. It requires the experience and expertise of a trade lawyer, right? To get a perfect trade application. You as a company, I would not want to submit a 70 to 80% solution of a trade application, right? That's inadequate. Even a 99% solution is inadequate. But the power of this is it allows, Katie, someone like you, or someone like you, Adam, to get to a 70 to 85% solution in, frankly, a fraction of the time it did before, so that you can spend your time in that last 10, 15 to 30%, which requires experience and expertise and things that AI can't provide. You're that much more efficient, you're that much more effective, particularly compared to a peer, a competitor, a colleague who's not using AI. And so I think finding how, people and AIs can work together, drawing upon the strengths of each, has always been the challenge of AI adoption. It remains the challenge with generative AI. I do think that generative AI opens up the aperture in terms of the number of people who can use it. Before, right, machine learning, data science, predictive modeling, it was great technology. It still required like a data scientist, right? It required a data science team. My company have tried to build tools that are much more consumer facing. It's still hard. With generative AI, if you can chat, which we all can, you can use it. Now, I still think there's a number of challenges there, but it moves us closer to a place where we have usable AI tools. So, Erica, do we have any questions from the audience at this point?
No questions at this time. Looks like we've covered everything that they were thinking.
Oh, great. Adam, yeah, go ahead.
I was going to say, to pick up on that, I mean, there is, and this isn't necessarily Gen AI related, but just AI more broadly. Obviously we work a lot with shipping companies, and we looked a lot at shipping issues. I had the benefit of being at a defense expo in the UK a few weeks ago, and was just amazed at how many AI companies have proliferated that focus on supply chain. and they're doing remarkable work in terms of tracking, identifying, monitoring, in some cases restricting companies throughout the supply chain. When you're looking, that doesn't sound so problematic when you're looking at a relatively simple widget, but when you're looking at a platform, for example, an aircraft platform, so think of the F-35, for example, I mean, there are hundreds, if not thousands, of component manufacturers in there. AI is just an incredible capability when it comes to identifying who those companies are, have they been listed, what's their ownership, what's their ultimate beneficial ownership, not just their immediate ownership. So I think that's one particular area where it's been remarkable, and I think will add a lot of value from a shipping and logistics standpoint.
Great. Well, Adam, Katie, thank you for your time today. Thank you for lending us your experience and expertise.